Hi everyone, today we will do legal dictation exercise number 119. You can get the PDF from description box. So ready? Start. Challenge in this appeal is to the judgment of a division bench of the Calcutta High Court disposing of the writ petition, the appeal and the application filed with certain modifications on the allegations that there was insertion of a variant element in the meter to bypass recording of actual consumption. First information report was lodged by the personnel of the appellant board. The provisional assessment was made and thereafter there was disconnection of electricity supply. A writ application was filed by the respondent number 1 making grievance that the disconnection of the supply was wrongly done and the provisional assessment as made claiming rupees 2,50,046 on the alleged ground of theft of electricity and or tampering of the meter was not sustainable. Learned single judge of the Calcutta High Court disposed of the matter in writ petition whereby and under the appellants were directed to restore electrical supply on deposit of rupees 20,000 by the writ petitioner. The appellants question correctness of the order on the ground that the disconnection of supply line was effected on 24/1/2006 in terms of the Regulation 52 of the West Bengal Electricity Regulatory Commission. The division bench referred to Regulation 52 and observed that the appellants have got right to disconnect supply line of electricity on fulfillment of the condition stipulated, but the same is required to be done following a particular procedure. It was held that due procedure was not followed. The division bench held that under section 126 of the Concerned Electricity Act 2003, the writ petitioner had a right of filing an objection thereof which has been filed by the writ petitioner under section 126(3). The appellants are required to pass a final order after giving a reasonable opportunity of being heard. The writ petitioner also has a right to prefer an appeal under section 127 of the Act against the final assessment order. The division bench therefore permitted the parties to pursue the remedy. It was, however, held that the disconnection of power supply was contrary to and was in breach of Regulation 52 and the writ petitioner was therefore entitled to be compensated. Accordingly, the cost of rupees 25,000 was imposed. Learned counsel for the respondent submitted that the High Court has taken note of the factual scenario and the legal principles applicable. The final assessment in any event is the subject to challenge. Since the final assessment has been challenged, we feel interest of justice would be best served if the same is disposed of in accordance with law. It is open to the appellant board and its functionaries to highlight before the concerned authority as to the maintainability of the appeal on the ground of alleged delay. It is needless to say that the said aspect shall be considered by the appellate authority. Let the appeal be disposed of in accordance with law without being influenced by any of the observation made by the High Court in the impunged order and by learned single judge. Thank you. Please subscribe my channel Steno.